Okay, 325 is Montgomery, Blair, Sibley versus Chauncey Joseph Watches. Justice Winslow is recused.
Good morning. Can you hear me?
Yes, we can hear you. We can't see you. Are you appearing by audio or video? There you are. Yep, we see you now, sir.
Good morning. I just would like to start.
Excuse me. Wait 1 second. We have to wait for Mr. Brady to appear. Here he is. Okay. Mr. Sibley, you may begin.
Thank you. I'd like to begin by reminding the court this is a case of not a privilege, but a fundamental right, which indeed Blackstone recognized in 1769 as self-defense, justly called the primary law of late nature. So it is not, neither can it be, in fact, taken away by the laws of society. I sit here 959 days since I applied for the right to have a handgun in my home for my employment, Sibley's Nuisance Wildlife Control, and as a matter of self-defense when outside of my home. And it will certainly be over 1,000 days before this court has the time to issue the opinion in this matter. There are problems procedurally, there are problems substantively with the law, and there are problems with this very court using an Article 78 proceeding to review the quasi-judicial behavior of the licensing officer, Chauncey Watches, below. My brief is laid out fairly clearly, the problems here. I would note again that I was forced to file the initial brief in this matter before the return had been filed as required by Article 78. I think that's a procedural error this court cannot ignore. I would point out that the licensing officer, acting in a quasi-judicial capacity, he had ex parte communications with my employer that he did not reveal, are not part of the record because they weren't sworn to, although they are in the transcript.
Mr. Sibley?
He also had ex parte communications with the sheriff.
Sir, Mr. Sibley, you have to listen. If somebody, judge wants to answer a question, you're going to have to, Justice Kern is trying to ask you a question.
I didn't understand. Go ahead, please.
You probably realize we sometimes interject with questions. I don't mean to cut off your train of thought or cut off what you want to tell us, but I have, like everybody else on the panel, reviewed your brief quite thoroughly, and it is a thorough brief. You've got, I think, 8 points in your brief. The due process has 4 or 6 subpoints, and then the reply brief is similar, very thorough. I guess where I'm really want to go is in appellate arguments, some of the manuals that you read say, go for the jugular. I'm not sure that's a good phrase, but go for the jugular. What would you say, Mr. Sibley, in terms of reversible error, are your best arguments, if that's okay with you to focus on that? Because we have read your brief extensively.
Sure, Judge. This is a multi-headed hydra of a problem. There are 6 or 7 jugglers that I could go for. Any one of them should give you nausea. Collectively, they should give you legal anaphylactic shock. It is so appalling to think that fundamental Second Amendment rights can be taken by the procedure here based upon the substantive law, which says I have to wait 1,000 days before I even get the right to have a handgun in my home. I have a skunk outside my apartment here that is terrorizing the neighborhood. I'm directed by the Steuben County Department of Health to catch and kill that skunk. The way we kill skunks is shooting them through the heart because the head has to go to the health department for the rabies check. I can't do that with a long rifle. I need that handgun for that very purpose for my employment. That's the first problem. But if all the jugglers here that I want you to consider is your own authority in an Article 78 proceeding to determine what is arbitrary, what is capricious, when the entire pistol permit process is sealed from public view. You do not know if there is a similarly situated litigant to myself who was granted a pistol permit and I denied it, and there we have an equal protection of the law. But in your Article 78 proceeding, you don't know that. You can't know that because the SAFE Act seals those records from view.
Mr. Sibley, what about the state's retort to that, as I understand it, that the issue of constitutionality is really not before us in this Article 78, And I'm certain that you're aware that you would have another remedy with respect to a declaratory judgment action on that.
Yeah, I get that argument. And unfortunately, the CPLR answers that for me under what? Section 103C, followed by 3001 and section 325, because this proceeding could and should and must be converted to a declaratory judgment for that very purpose, in order not to send me back to the square one and commit me to another 1,000 days for dealing with this.
And did you make that argument in your brief? I must have missed it.
Yeah, no, it's in there. And it's also in the companion case as well.
Thank you.
Okay. Is that it, Mr. Sibley?
Well, I actually don't know how much time. I wanted a couple minutes left, but
Okay. You got to wrap up. So you got about a minute left once you wrap it up.
all right, I'll save that for rebuttal.
No, Mr. Sibley, there's no rebuttal.
Oh, well, in that case, then I will end with this, very clear statement. This is not a privilege that I'm asserting here. It's not a driver's license. What we're talking about here is a fundamental right. And the state of New York, through a licensing officer, even though he happens to be a judge, does not have the right to take that away upon this argument that I had some frivolous pleadings filed 18 years ago. If that's all I'm allowed to say, that's all I will say. I'll leave it off to you.
Thank you, sir. Counselor?
Good morning, Judge. Obviously, this case has been thoroughly briefed, and I don't know if the court has any particular point that it's interested in. I would invite the court to ask me a question. As to what's proceeded, as far as conversion, it's true the court can convert, but the court can do that on an appeal. The court doesn't have the jurisdiction to do that in an original proceeding. So that's the distinction, and that's why conversion is inappropriate here. Secondly, as far as Mr. Sibley hasn't applied for a premises permit. He's applied for a carry concealed permit. So the right rubric is a little bit different than as far as whether or not it's a fundamental right under the Second Amendment. I guess the most important thing I would like to get out is that the court, the licensing officer, rationally determined that Mr. Sibley was not of the moral character necessary. He did not have any confidence in Mr. Sibley's ability to follow the rules that govern possession of a pistol permit. Mr. Sibley has a long history, which the court reviewed before it made this determination. A lot of this is in the record. I don't need to, but I would point out that after he was suspended from the practice of law in 2008 in Florida, this court reciprocally suspended his right to practice law in New York. And this court.
Mr. Brady, pardon my interruption real quick, but if I recall in your brief, you've conceded that this provision that the licensing officer as a precondition for granting a permit would be to be readmitted to the bar on that issue. You've conceded that the licensing officer should have done that, correct?
Yes, there's no authority that we could find to support that condition. So okay. Yes, we would ask the court to annul the determination just to that extent. But I did want to point out that in 2009, this court, in imposing reciprocal discipline, found that that the petitioner here, by his conduct, had demonstrated his disregard and disrespect for the judiciary, as well as his absence of remorse. There's a lengthy history about, it's in the record, about the vexatious litigation he's brought.
Mr. Brady, we know the record very well. Thank you.
Okay, so unless the court has a particular point about any of the procedural arguments, I'm prepared to rest on my brief.
Thank you, Counselor. Thank you both.
Thank you.